Gun owners, get ready. The federal courts have just delivered a groundbreaking ruling that will transform everything regarding concealed carry. What has topped the list of restrictions is truly astonishing. This isn't merely another legal ruling, it's a complex mix of victories and significant setbacks that could redefine your Second Amendment rights nationwide. The surprising details will leave you in disbelief. So, hit that subscribe button right now because you need to know what just transpired regarding your constitutional rights. The insurance mandate revelation. Here's something that hasn't been discussed. This case has just invalidated a $300,000 liability insurance requirement that would have excluded 90% of Americans from their carry rights. Consider this. The average American struggles to manage a $400 emergency expense. Yet, one state attempted to compel gun owners to carry insurance worth more than most people's homes. The court documents indicate that this was not about safety, it was an economic assault on the Second Amendment. Internal state emails revealed officials rejoicing over how this would drastically decrease the number of carry permits issued. But here's the shocking twist. The court didn't merely block this requirement. They established a legal precedent that could dismantle similar initiatives in 15 other states that are currently contemplating identical insurance mandates. However, what they permitted to remain in the vehicle carry regulations will infuriate you. The vehicle carry rights split decision has resulted in the most perplexing legal situation in Second Amendment history. You can now keep your firearm ready in your personal vehicle. No longer do you have to unload and secure it every time you drive somewhere. This is significant because 2 by 3 million Americans rely on their vehicles for work every day and were being turned into easy targets. The court found no historical evidence to support the forced disarmament in private vehicles, deeming the state's argument historically unfounded. But here's where it gets truly outrageous. While you can carry in your Honda, you're now left completely vulnerable on public buses and trains, where FBI statistics indicate you're 300% more likely to face a violent attack. The same court that acknowledged your car as an extension of your home has simultaneously deemed public transit a constitutional no man's land. This results in a strange scenario where a millionaire in their Tesla enjoys more rights than a working class individual commuting on the subway to their job. The property rights ruling becomes even more convoluted, and what private businesses are now allowed to do will astonish you. Private property, default private property, default rule, rule, overturned. The court has just dismantled what gun control advocates referred to as the vampire rule. This victory is more significant than most people realize. Previously, anti-gun states were attempting to prohibit carrying in any public space unless you obtained written consent from every single business owner. This would have led to a nightmare situation where you would need a lawyer just to go grocery shopping. The economic impact study hidden within the court filing reveals that this rule would have influenced 847,000 businesses and rendered carry permits virtually useless. But here's the clever part. The court didn't merely block this specific rule, they established that the responsibility of prohibition lies with property owners, not gun owners. This means that no guns allowed signs must be prominently displayed, and business owners must actually request that you leave before you can be considered trespassing. The decision cites historical precedents showing that businesses in the colonial era welcomed armed customers for their protection. However, the court's logic takes a complete turn when it comes to public gathering restrictions, and the ruling regarding the 100 FT buffer zone will leave you absolutely shocked. Public assembly. Public assembly buffer zones upheld, buffer zones upheld. Get ready to be infuriated. The court has just legalized 100 FT gun-free zones surrounding any authorized public gathering. And the definition is so expansive that it's downright frightening. We are not merely discussing political rallies here. This encompasses farmers markets, outdoor concerts, charity walks, food truck festivals, and even authorized birthday celebrations in public parks. The court referenced post-Civil War legislation from 1867. However, here's what they conveniently overlooked. Those historical laws were only applicable during active voting or legislative sessions, not during regular community gatherings. Court documents indicate that in just one major city, these buffer zones will establish gun-free areas that cover 23% of all public spaces during the peak summer months. The mathematical analysis reveals that in urban settings, these overlapping zones could render legal carrying nearly impossible during weekend hours. But here's the most frustrating aspect. Criminals do not apply for permits, so they remain unaffected by these buffer zones. Only law-abiding citizens are disarmed while predators roam freely. The endorsement requirement they upheld exacerbates this issue. And just wait until you learn how challenging it has become to even obtain a permit. The four-person endorsement requirement remains. The four-person endorsement requirement remains intact. The court has just upheld the most discriminatory permit requirement in American history, compelling applicants to find four reputable individuals willing to jeopardize their reputations by vouching for your character. This is not about safety. It is about establishing a social punishment system for gun owners. Internal analyses from civil rights organizations reveal that this requirement has a devastating disparate impact. Approval rates plummet by 67% for minorities, 54% for single women, and 43% for anyone who has recently relocated. Consider this. If you are new to an area, recently divorced, or simply private about your political beliefs, finding four individuals willing to endorse you on government documentation becomes nearly impossible. The court disregarded evidence that similar requirements were historically employed to deny rights to freed slaves and immigrants. Here's the most unsettling part. There is no clear definition of what constitutes a reputable person, granting officials the power to arbitrarily deny endorsements. One county has already dismissed endorsements from military veterans, arguing that their service does not ensure good character. However, the entertainment venue ban they upheld next truly illustrates how they are transforming America into a gun-free victim zone. Entertainment and education. Venues prohibited entertainment, and education venues are now prohibited. The court has effectively turned every family outing into a potential death trap by endorsing carry bans in zoos, parks, beaches, libraries, museums, and entertainment venues. The extent of this is staggering. It impacts 127,000 locations across the country where American families enjoy their leisure time. The court accepted the state's claim that places of amusement and education are historically sensitive, yet their research was absurdly incomplete. Archaeological findings indicate that armed citizens frequently visited similar venues throughout the 1800s, and advertisements from that time actually encouraged patrons to come armed for their own protection. The court completely disregarded FBI data on active shooter incidents, which shows that 34% of mass attacks occur in these specific types of venues because attackers are aware that victims will be unarmed. What truly reveals their agenda is this. While they prohibited firearms in children's zoos, they imposed no restrictions on violent offenders with restraining orders or gang members entering these same areas. The economic repercussions will also be catastrophic. Insurance companies are already increasing liability rates for venues in gun-free zones, knowing that disarmed citizens cannot prevent attacks. Yet, the public transit ban represents their most alarming overreach, and the rationale will leave you in disbelief. Public transit turns into a criminal hunting ground. Public transit is becoming a hunting ground for criminals. Yet, the court has concluded that cramming defenseless individuals into confined metal boxes with no escape routes somehow enhances their safety. The historical analysis they relied upon is entirely misleading. Those 1800s railroad regulations were only applicable to intoxicated passengers causing disruptions, not sober individuals carrying protection. Current transit crime statistics unveil a terrifying truth. A staggering 89% of transit assaults occur when victims are unable to escape. Moreover, response times average 8.7 minutes in subway systems, where attacks typically last under 2 minutes. Here lies the most frustrating contradiction. The same judges who acknowledged your vehicle as deserving of Second Amendment protection have simultaneously ruled that buses and trains are constitutional no-go zones. They have effectively established a two-tiered system where your rights are contingent upon your ability to afford private transportation, rendering this the most anti-working class ruling in decades. Conclusion: this ruling demonstrates a deliberate assault on your fundamental right to defend yourself and your family, transforming ordinary Americans into defenseless victims in environments where malevolence flourishes. Your constitutional rights are under unprecedented threat. Each day we delay is another day that criminals gain the advantage while law-abiding citizens become easy targets. If this doesn't ignite enough anger in you to subscribe and share this with everyone you know, then you may already be part of the issue. For silence in the face of tyranny equates to compliance.